We're here for a pretrial and a bond violation. We're ready to resolve the bond violation. She will admit to the allegations of contact and would like to provide the court some context if you would allow that.
Go ahead.
Your Honor, I do admit I was wrong. Let me start there. I was wrong. When I got out, I thought that she was going to be at her mother's house. When we went to arraignment, they said she's going to be at her mother's house and I could return to my home. But I didn't know until the end, when they were releasing me, that I could not return to my home. So that was a surprise. And I called the police like I was told to do. She packed up some of my stuff. She left our marriage license on the front of my driver's side. I didn't know we were married, Your Honor, because we had gotten married a couple of weeks before and we had talked about not filing the marriage license. And so she filed the marriage license after the incident. And I did not know that we were married until she left it on the seat. And so when I did call, she had packed it up. She'd packed up my stuff. I did leave, but then I realized she didn't give me shoes. And so I called the police officers back. I was away from the house. I was down the street. I was trying to do the right thing. They got called emergency, so I was waiting longer. And I saw my son get out of the car. And I saw her pull the trash cans up. I did not approach them. I did not try to approach them. But when I saw my son, that's what broke me. Is I saw my son. And so I did violate, Your Honor, I did violate, but I was not aggressive. I did not approach them. I did not come near them. I did send text messages, but I didn't understand with the marriage license and it broke me. My son broke me. That's why. And I wanted to know if there was hope. That's all. And I do acknowledge I was wrong. I do learn, and I will not contact her again. 100%.
I will add, Your Honor, she has been in custody for about 5 days, I believe. If she were to be released, she would be staying at a hotel nearby. The house was recently flooded, so she actually has funds from the VA to stay somewhere else. There's work being done on the house. So given her admission and her owning up the fact that she did violate the court's orders, I'd ask that you sentence her to those 5 days.
What are we doing on the pretrial?
We're asking for an adjournment
Right.
on the pretrial.
Do people have something to say in this?
Yes, Your Honor, we would object to that. Given the nature of these texts and the fact that they were sent, she was, I believe, arraigned on the 22nd, sent these immediately after getting out and being told not to have contact. And in those messages, directly acknowledges that she was not to be having contact, continuously telling the victim not to contact police, and then sending other manipulative messages to the victim, intending to make her feel bad for contacting the police or trying to contact police.
When's my next day?
May 13th.
May 13th.
Yes.
I'll adjourn the pretrial in this matter to May 13th. At that time, I'll also sentence her on the bond violations on that May 13th, and then her bond at this time, given what I've seen here, her bond will continue as revoked. And
Yes, Your Honor.
thank you.
Teresa Clara on behalf of probation. Your Honor, Mr. Anderson is before the court for a violation of probation hearing. Mr. Anderson violated his GPS tether that he had on. He entered into the exclusion zone, including going to the victim's residence, and also took her vehicle. They then tracked the GPS where he removed the tether and left it in Flint. Mr. Anderson, failed to enroll in the domestic violence program, and he failed to continue to report, as he should. I would also like it, known to the court when Mr. Anderson walked in and up to the podium, he was looking, trying to make direct eye contact with the victim who is present today. Your Honor, given the violations of Mr. Anderson, and his clear non-compliance with what this court ordered, probation is asking that the court sentence him to 93 days in jail, credit for 33 days that he served to date, to serve the balance, waive remaining terms of his probation, accept his financial obligations, and discharge him from probation without improvement.
Ms. Coons.
Your Honor, my client would like to admit to the violations with explanation. I think that he is very apologetic about his actions. He just lost his sister and he's grieving right now. He's not in the right state of mind, and he understands that he has made some poor decisions here. As to the no contact violation, he had news that the complaining witness was possibly selling his stuff. He does understand that the proper remedy would have been to go through civil court after discussion with him. And particularly to the vehicle was in both their names, but again, I did discuss the civil court with him. As to the lack of payment, it's due to a lack of monetary funds. His sole source of income is from Social Security. He's been homeless since the beginning of this case and just fell on a hard patch in life. And that goes for the domestic violence program as well, as to why he didn't complete that. In addition, he did not have transportation. So, Your Honor, we would leave it inside the discretion of this court as to the recommendation, but we would ask for some type of leeway on account of him just not being in the right mind state. He's grieving and he just lost his sister.
And Your Honor, I just would also like to make it known to the court. I had a meeting with Mr. Anderson. It was made extremely clear where he could and could not go. So it wasn't a stuff been made about the truck, as he indicated that it was in both of their names. He was told what he needed to provide to this court if that he wanted to pursue that. Just taking it upon himself and leaving his daughter's home where he was staying in Detroit and coming here and going to her home and taking a vehicle was against what he was instructed to do. He knew full well that he should not have been in the exclusion zone, period.
Anything you want to say, sir?
I came down here when I seen her. And I have friends here that I've been, and I understand that when I talked to you, you made it clear to me 5 miles. I understand that. But she told me that the police don't have time to be running over there to see about my things, and that I shouldn't come.
She who?
The lady that was just talking.
Ms. Polera?
Yeah. And that you said not to even come to Washtenaw County at all. And I'm like, you know, she wrote it on this paper. So, Your Honor, I'm just.
Well, why'd you take the GPS tether off then?
I was going through some things. I lost everything. I was wrong.
Oh, I know.
And I understand. I mean, I was going through some things, Your Honor, with this whole situation.
Court will accept the admission to the violation. Court will follow the recommendation of probation. I will waive remaining terms accepted as financial obligations, discharge him from probation without improvement. Sentence you to 93 days, Washington County Jail. Credit 33 served. Defendant is to serve the balance. I'm not even going to consider an early release. Thank you.
Thank you, Your Honor.
All right, sir.
This courtroom session centers on two serious bond and probation violations that both end with harsh consequences. The hearing begins with a woman who admits she violated her bond by contacting the protected person after her release. She tells the court she was confused about where the victim would be staying, says she didn't even realize they were legally married until a marriage license was left on her car seat, and emotionally explains that seeing her son broke her and led her to send messages. Even while admitting she was wrong, prosecutors point out that her texts were sent immediately after release, directly acknowledged the no-contact order, and included manipulative messages meant to pressure the victim and discourage police involvement. Despite the emotional explanation and defense request for leniency, the judge is not persuaded and rules that her bond will remain revoked. With sentencing on the violation set for May 13th, the second case involves Mr. Anderson, who is brought before the court for multiple probation violations after cutting off his GPS tether, entering a strict exclusion zone, going directly to the victim's home, and taking her vehicle before abandoning the tracker in Flint. On top of that, he failed to enroll in domestic violence treatment, stopped reporting as required, and even attempted to make eye contact with the victim in court. His attorney explains he is grieving the loss of his sister, is homeless, lives on Social Security, and made poor decisions during a difficult time. But probation confirms he was clearly warned where he could and could not go and knowingly violated every condition. When Mr. Anderson admits fault but offers excuses, the judge makes the decision final 93 days in jail, credit for 33 already served. No early release, remaining probation terminated, and only financial obligations left in place. The courtroom ends with a clear message. Emotional explanations do not outweigh repeated violations. And when defendants ignore court orders, the consequences are swift and unavoidable. If you want more real courtroom breakdowns like this, hit like, subscribe for daily cases, and drop a comment telling us which case you want covered next.